All rise. All persons having business for the Honorable Chief Judge and Associate Judges now presiding over the District of Columbia Court of Appeals draw near and give your attention. God sent the United States in this honorable court. This honorable court is now in session. Be seated and come to order.
All right, good morning and welcome to the District of Columbia Court of Appeals. We have one matter set as a special sitting this morning, and that's the case of Gregory Terrell versus United States. Counsel, are you ready to proceed?
Good morning. May it please the court. Adrian Madsen on behalf of appellant Gregory Terrell. I'd like to reserve 3 minutes for rebuttal.
All right, thank you.
A sentencing process which creates a significant possibility that misinformation infects a sentencing decision violates due process. At the time of sentencing in this case, the complainant, Darren Lee Marshall, made statements indicating that the shooting in this case rendered him infertile and impacted his urological function. More than 5 years later, Mr. Marshall, through DNA evidence, was arrested for a 2007 rape involving ejaculation, a rape he committed about a year after sentencing in this case and at the time of those statements. Several months later, Mr. Marshall pled guilty to that offense. This created a significant possibility that misinformation infected the sentencing decision in this case. The United States has waived any argument regarding the application of two potential procedural rules, Shepard and Head. The United States has disavowed in this court reliance on Shepard, on which it and the trial court relied below.
Counsel, may I interject with a couple of questions on the argument about the misapplication of the Shepard standard versus the Head standard? If we were to agree that the trial court may have improperly applied the standard under Shepard, what is the harm there ultimately?
Sure. The harm is that the trial court did not consider the motion on the merits. That is, if the trial court was considering under Shepard, as is well established in the context of a 23-110 motion, there are 3 exceptions to the requirement of holding a hearing. None of those exceptions applied in this case. The harm is that Mr. Terrell was not given an opportunity to prove up the claim. That is, the United States disputed and argued that, well, perhaps the statements were true at the time of sentencing, even if they were false a year later, as is now on the record before this court. Mr. Terrell made efforts to substantiate that.
Right. So under the Head standard, you are assuming that the trial court would have granted a hearing. Is that the crux of your argument?
So, Your Honor, no, not exactly. That is, Head is just not applicable at all on these facts. Even if the court was to look beyond waiver and look beyond the procedural unfairness of considering any argument regarding Head on the merits. So what Head says is that
well, if you don't think Head applies, I won't take you down that road. But how do you get around the question of whether or not these were successive claims? I know
Sure.
Mr. Terrell originally raised the challenge to the victim witness statement or the veracity of the victim witness statement in a 35B motion to reduce his sentence. But essentially, he's making the same arguments in the 23-110 motion that is before us on appeal now, isn't he?
So a couple of things, Your Honor, in terms of what successive means within the scope of 23-110. It means an identical legal claim. Mr. Terrell has never raised before the court what he raised that's at issue in this appeal. That
Well,
is
the
the
underlying
violation.
facts are the same, aren't they?
Some of the underlying effects are the same. What I mean to
Or
say.
facts, not effects, the underlying facts.
Yes, sir. Some of the facts, and when I say some of the facts, what I mean is that so the plea in which Mr. Marshall pled guilty happened in September of 2012 at a time when Mr. Terrell was incarcerated. So the information the judge had at that time was about the arrest. It actually didn't have any of the underlying facts about the rape.
Well, I agree that the timing of the procedural bar may be problematic, which is why I say, suppose you're right that Shepard may not have applied because it was unknown at the time of sentencing that 7 years later, the victim would commit the rape and father a child, presumably, I think is what you're alleging. So, okay, but about the successive nature of the substance of the claim, that's what I want to focus you on. Essentially, Mr. Terrell, isn't he arguing the same thing, that the judge relied on incorrect information in the victim witness statement? And so I don't see how that's established in the record what the judge relied on at sentencing, or that he relied on the victim witness statement at all. And if he did, whether that was the primary focus of his sentence. That there's not a lot in the transcript of the sentencing hearing, but what's there seems to indicate that the trial judge may have been focused more on Mr. Terrell's criminal background and that he had numerous prior offenses. There's a comment in the transcript from the sentencing that Judge Gardner, I believe, pushed back a little on the government's recommendation of a sentence in the 8-year range on the lower end of the guideline, because I think, I'll quote him directly in a minute, but he was concerned that that's reserved for someone who doesn't have as many offenses as Mr. Terrell does. So there's nothing that I could see in the sentencing transcript where the judge even comments at all on that part of the victim witness statement. Is there?
I agree that there is nothing in the sentencing transcript that indicates that where the trial judge expressly comments on that. I agree with that, Your Honor.
Don't you have to show that there was some undue reliance by the trial judge on the fact that the injuries left the victim impotent and infertile?
So, Your Honor, what the showing that is required is a significant possibility that misinformation infected the sentencing decision. That is, in order to offend due process, it may not even be that the false statements did impact the sentencing. It is a significant possibility. That is the standard that is required. And so I would point to several things that are addressed both below and in the briefs that suggest that. That is, one, the statements later of Mr. Terrell's trial counsel, who the Judge Gardner credited in a later hearing about what she believed the sentence would be, that it would be a sentence in the 8 to 12-year range, and that one of the reasons she believed that the sentence had exceeded that was what at the hearing trial counsel referred to as the big surprise, referring to Mr. Marshall's statements. That's one fact I would point to. The second fact I would point to is that in the Rule 35B context, Judge Gardner never says, I didn't rely on those statements. He says they don't warrant a reduction in sentencing. He doesn't say.
Yeah, but if the request in the Rule 35 motion was to reduce the sentence because of this misinformation, and the court says, I'm not going to reduce the sentence because of this claim of misinformation, I mean, it's very implicit, if you can say very implicit, that that the court was saying, I didn't rely on this. And I mean, if the court had accepted your client's argument in the Rule 35 motion, then presumably the court would have reduced the sentence at that point.
Well, again, Your Honor, I'll highlight that at the time of the Rule 35B motion, the information that was before the court attached to the pro se motion was that Mr. Marshall had been arrested.
Well, I'm just getting to your point that the court didn't disavow having relied on the misinformation in denying the Rule 35 motion. And I think effectively the court did. So I realize you're saying that the facts were slightly different by the time of the 23-110, but just on the point of whether the court disavowed reliance on the misinformation,
You're right. I think the court, if the court was going to disavow reliance on the statements, it could have easily done so. It could have said this didn't contribute to the sentencing
it
decision
could
at
have,
all.
but I think you're asking us to read a lot into the absence of that particular point, as opposed to what's clearly a denial of the Rule 35 motion on the very same grounds that. But that brings me back to, we were talking about successive. I mean, is it your position, and are there any cases that say that a Rule 35 motion, and I'm not sure if that's considered collateral or not, post-conviction or not, but that vehicle can't give rise to a successiveness vis-a-vis a subsequent 23-110. I realize you're saying that you're making your client made a slightly different legal argument in the 23-110, but focusing more on the procedural vehicle aspect, is that part of your position?
Yes, Your Honor, and I would direct the court to, so it does not, there is a case that I believe answers Your Honor's question, although it did not involve Rule 35. What I mean to say is Bradley versus United States, which is cited in the briefs, there in defining what successive means, this court said only the factual allegations in the second motion are new. The legal claim in the second, ineffective assistance, is the same as in the first. Because the second motion stated an identical legal basis for relief, ineffective assistance of trial counsel. So that is, this court has defined successive to mean raising an identical legal claim for relief. And there is no dispute that Mr. Terrell's 2022 23-110 motion involved a different legal claim.
I mean, surely that can't be right. I mean, even if we stay within the same vehicle, multiple 23-110s, is it your position that a defendant can file a sentencing claim based on the Eighth Amendment and then have that rejected, and then subsequently file a sentencing claim based on due process and have that rejected, and then subsequently file a 23-110 based on 14th Amendment, equal protection? I mean, is that your position?
You're right. That wouldn't. My position is that wouldn't make it successive. That is, those might be second motions, but it wouldn't make it successive. And what the trial court relied on, one of the grounds the trial court relied on to deny the motion here was to say that it was successive. And so this court has been clear that what that means is, and I agree, it may be a closer question if we're arguing about different vehicles for challenging under the Fifth and Eighth Amendment, the sentencing decision, but a claim of ineffective assistance of trial counsel versus a plea for leniency under Rule 35B versus a due process claim are very different.
Well, but isn't a rose by any other name still a rose? And essentially you're asking, Mr. Terrell is seeking in each of these vehicles the same relief, which is a reduction in sentence. And am I interpreting that right? So even though it's framed as a due process claim now, and when he filed his first 35B motion, it was framed as a reduction in sentence. And then when he filed the second 35B motion, it was a claim for leniency and a reduction for sentence. Ultimately, his goal is a reduction in his sentence.
Certainly I would agree, Your Honor, his goal is a reduction in sentence. But again, this court hasn't said that what successive means is what the person's underlying goal is. That is, that may.
Or what their underlying relief being sought. Maybe that's a different way. And in each of these vehicles, it's the same thing, isn't it?
Well, no, Your Honor, it's not. So under Rule 35, if the court, let's just say hypothetically, the court had granted the motion, it would have done so by simply on the papers reducing his sentence. That is, however, the court was going to do that. What Mr. Terrell is seeking here is a resentencing without the false information that the sentencing court relied on at the time. Certainly, he would hope that that would lead to a better result for him. But what he's seeking is a resentencing procedure without taint of the false information.
And then, you know, we're also have the question of how do we know it's false? I mean, not only do we not know that the trial judge relied on, that wasn't the whole sum and substance of the victim impact statement. That was a part of it, that the victim was left, so he claimed, impotent and infertile. So there's so many, I guess, speculative missing pieces of information here that make it, it seemed to me it would be the burden of the appellant here to fill in the blanks about how there was undue reliance, how there was any reliance by the sentencing judge, how it overshadowed what he does say. I found one part of the sentencing transcript with it. The court, in response to the suggestion that he be sentenced on the lower end of the guideline, the court says, well, I suppose in a context like this, 8.5 years would be reserved for somebody who hadn't done too much of anything before. I don't know it would be reserved for somebody like him, referring to Mr. Terrell, but for the fact that I guess he didn't shoot straight, the man would have been dead. So there's nothing in there to what information there is in the sentencing transcript. None of it seems to focus or indicate that that was the focus of the sentencing judge.
So a couple of things, Your Honor. I'll note that in this court, the government concedes that if the court finds that no, the motion was not procedurally barred, and I'm not saying the government concedes that it is not procedurally barred, but if the court finds that the motion was not procedurally barred, the government concedes that the proper remedy is to remand for a determination of the falsity of the statements or not. And as is now in the record here, Mr. Terrell was sort of cut off at the knees in his effort to do that. That is, pursuant to Brown, sought to subpoena records that would have elucidated the falsity of the statements. And as this court has repeatedly stated in matters that occurred outside the trial record, the means by which to resolve that is an evidentiary hearing. And so to answer Your Honor's question in answering, how do we know that they're false? Well, Mr. Terrell was deprived of I think he has shown a significant possibility that the statements were false based on the facts. But I agree that the way to resolve that is through an evidentiary hearing after obtaining the relevant records. And so I just wanted to note that.
But counsel, it's not a significant possibility that the statements themselves were false, but it's the significant possibility of taint based on them. And so if we're going to be going through that parsing exercise, to what extent do you think it changes, or should it change at all, our analysis that trial counsel actually pushed back on the statement, had the opportunity to?
So a couple of things, Your Honor. One, the information that would have demonstrated the falsity of them was not available to anyone at the time of sentencing, right? So this isn't a situation where the fact that would have demonstrated their falsity hadn't even occurred, right? That happens about
trial counsel pointed out that evidence that was true didn't exist either. There's no medical corroboration. This is just someone talking.
Sure, it's one thing to say there's not evidence to, in the trial record to support what this person is saying. It's an entire another thing to say what this person is saying is false. And so to answer your Honor's question, I suppose the fact that trial counsel, if the subsequent facts had never come to light, I don't think Mr. Terrell would have had a due process claim here just based on the fact, it had been recognized that there wasn't evidence to support the statements. We have information that strongly suggests the statements were false, not just that there wasn't evidence to support them. And so I think that's a very different circumstance.
You also referenced the trial counsel at the hearing, just having being surprised by that, or everyone being surprised by it when it came up. How do we weigh that against some of the other statements? Like Mr. Terrell appeared to be very angry, and it was easily observable by the judge and other factors. It seems like this is really taken in isolation, as the chief referenced earlier. But there are other things even from some of the sources you're telling us about.
So Mr. Terrell doesn't need to show that under any standard that the false statements were the cause of the exact sentence, right? Just that they were one cause. So it's.
Was it just that they're one cause, or that they're a significant cause?
So the standard again is a significant possibility that the false statements infected the sentencing decision. That is, it doesn't have to be sole cause, doesn't have to be primary cause, some impact on the sentencing. And so there are the other statements that Your Honor is referencing. Certainly those could plausibly have impacted the sentence as well. But so what Mr. Terrell does not need to do is to show that those other factors Your Honor is referring to didn't impact the sentence, rather just that the significant possibility that the false statements, the misinformation infected the sentencing process in some way.
Can I ask you quickly about abuse of the writ? So I see your argument about why these weren't successive, but then that would seem to point to abuse of the writ. And I realize, your argument was something can't be both successive and an abuse of the writ, which I think is probably right, but they can be one or the other, right? And that's that seems to be the government's point. So what's your response to that?
Sure, Your Honor. Just I don't want to speak for the government, but I think they've actually made the same argument here that it is one or the other, and it can't be both. This court has held in Junior versus United States, and logically it just can't be both. I'll note that what the trial court found was that it was successive. The trial court did not find that this was an abuse of the writ. But to answer Your Honor's question, even if this was an abuse of the writ, there of course are exceptions, cause and prejudice that apply there. One of those exceptions, and I'll say that this court has equated the abuse of the writ doctrine with the word second in the DC Code 23110 statute, right? So we're not talking about sort of three procedural bars here: second, successive, and abuse of the writ. We are talking about successive and abuse of the writ. And so focusing now on abuse of the writ, so as argued in the briefs, Mr. Terrell, I think, reasonably believed that his trial counsel, so, and it sort of depends on whether we're talking about Shepard or Head here, but reasonably believed that his trial counsel was going to represent him under 23110. That is, she had written to him, the correspondence is in the record many times, that she was going to seek appointment. I will do this. I will represent you under 23110. So certainly in terms of the timing of that and why Mr. Terrell would not have raised it earlier, counsel's representation certainly contributed to that. And as grounds for why that can be cause, I would direct the court to White versus United States and Brown versus United States, which are both cited in the briefs, in which this court has held that the unavailability of claims resulting from trial counsel's actions are cause for delay, where counsel's own failure to effectively communicate with the defendant led to the delay in filing.
But he filed he did file an initial 23110, right? And
He did.
without counsel.
Without counsel.
And this argument was available to him prior to that 23-110. Am I right?
Yes, Your Honor, he included that in the sense that Mr. Marshall included in sort of in the conclusion section, not as a freestanding claim in the pro se motion, and his counsel did not elucidate evidence regarding that at the hearing or otherwise pursue the claim. The trial court didn't consider it on the merits. So I certainly don't think this is a circumstance, and I think the record would belie a circumstance that that Mr. Terrell has not sought to bring this issue to the trial court's attention. But I just want to note again that the trial court did not find that this was an abuse of the writ. I recognize that this court is not constrained and can affirm on alternative grounds, but the trial court in this case did not find that this was an abuse of the writ. Regarding prejudice as an exception to abuse of the writ, I would just point the court back to the same evidence that I have already referenced in terms of suggesting a significant possibility that the trial court relied on false statements or those infected the sentencing process. I see that my time is expired. Unless there are further questions at the moment, I will sit down.
All right, thank you, Mr. Mazda. We'll reserve your time for rebuttal.
Thank you.
May it please the court, Kevin Burnish, of the United States. I think just piggybacking off of appellant's argument here, there have been lots of procedural bars that have been sort of thrown around in the briefing, but I think really, and I'm happy to talk about Shepard and Head, but I think the most appropriate procedural bars here would be that this motion is successive or an abuse of the writ.
Which one is it in the government's view?
If I had to pick, I would say successive, but honestly, I think it's 1A and 1B, and I'll make the case for both of them. So starting with successive, I think it's already been noted here today. Mr. Terrell did file a Rule 35B motion in which he made essentially the exact same claim that he's making here. And I would note that attached to that motion was the news article, which went into great detail about the facts of the rape, who was raped, where it happened. And so Judge Gardner had all of that information in front of him when he was deciding whether to reduce Mr. Terrell's sentence. And I think, as has already been noted here, he says that that information does not warrant a reduction in sentence. And so I think it is very implicit in Judge Gardner's ruling. And of course, he was the sentencing judge, so he is in the best position.
What makes something successive? I guess in the government's view, appellant's counsel argues that it has, because the due process 23-110 claim filed several claims after the 35B claim was a different legal claim, that it couldn't be successive. I guess what would be your best argument as to why it could be successive?
So I think Sanders, which is a Supreme Court case from the 60s, I think does a really good job of laying out, we cited in our brief, but I think it does a really good job of laying out what is successive, what is the same ground. And it takes note to say that the same ground can be supported by different legal arguments or couched in different language or vary in immaterial respects. And I think it really is sort of a common sense question for this court. I don't think it's about whether it's the same exact legal argument or whether it's the same exact facts. I don't think you can have a bright line rule like that. I think it's more about sort of at the premise of a lot of this court's questions this morning. Does it seem like essentially the same claim? Is it in all material respects the same claim? And here it is in all material respects the same claim. It's the same information that he's putting forward many, many years later. Again, he attached the news article, and Judge Gardner, I would also note, when he denies the Rule 35B motion, he doesn't say that these are mere allegations. The language of his denial almost assumes they are correct. I mean, he doesn't go that far, but he gives, I think, Mr. Terrell a lot of credit in that he lays out Mr. Terrell's arguments very clearly. about the impotence and infertility are not true because the victim was recently arrested for rape and also fathered another child. And then he follows it by immediately saying this information does not warrant a reduction of sentence. So I think the fairest reading of his order is that he did consider this information very seriously. And he has essentially said it played no role in his sentence, which I would also, I think Judge Gardner's statements along those lines are even more powerful evidence he did not rely on it. But if you look at the sentencing transcript, I don't think you can fairly read the sentencing transcript and say that Judge Gardner relied on this very passing remark that Mr. Marshall made. And so I guess I would highlight two things implicit in that. First, it is a very passing remark. Mr. Marshall is talking about a lot of other things when he makes this very brief reference to this alleged impotence. And then the other thing is that Judge Gardner is really talking about, when giving his sentence, the fact that Mr. Terrell could have killed Mr. Marshall, the fact that Mr. Terrell has an escalating criminal history. And I think the record therefore reflects that that is what Judge Gardner really relied on.
Counsel, do you have any authority either from our court or, the federal context is pretty analogous to the notion that a Rule 35 and a post-conviction, here 23-110, federally a 2254 or 2255 can be successive?
So I don't have a case offhand that sort of squarely has that language that Your Honor just referenced. I think I would point this court to Vaughn, which we also cite in our brief. And I'm trying to remember exactly what the motions were there. There were so many in Vaughn. There was a quorum nobis motion. There was a 23-110. I believe there were several 23-110s. I believe there was at least one Rule 35, although I'm not certain about that. But I think the point that this court made in Vaughn was that the new motion, the new collateral attack, was barred because the defendant cannot just continue to raise these claims over and over and over and over again in an endless litany of post-conviction motions. I think that's what successive is trying to guard against. I think the only other thing that I'll point this court to is that we've talked a little bit about 23-110E, which sets out the successive rule. And it says the court shall not be required to entertain a second or successive motion for similar relief on behalf of the same prisoner. And I think that word similar sort of contemplates that perhaps it's due process one time, or it's Eighth Amendment the next time, or it's ineffective the next time. But if it is a similar motion, if we're really talking about essentially the same thing, then it should be barred as successive. But alternatively, I can also lay out the case for why it's an abuse of the writ. And I think here I would rely on the fact that he has filed a previous 23-110 motion. That 23-110 was litigated pretty thoroughly. A hearing was held. He testified at that hearing. So he certainly could have complained about Mr. Marshall's statements at that hearing.
Right, but the focus of the prior 23-110 was really on ineffective assistance of his trial counsel.
It was. So it's a slightly different, claim in the 23-110, I guess, slightly different posture. But he could have raised his due process argument in the 23-110 as well, and he did not do so.
What are the factors that we would consider differently if we were to view this as an abuse of writ, as opposed to a successive claim?
I think the factors would essentially be the same. This court would have to look at, it's a different doctrine, of course, in the sense that successive is he already brought it up. Now he's bringing it up again. Abuse of the writ is he didn't bring it up before, even though he should have. But then in either case, you have to look as to whether he has shown cause or prejudice. And when you're dealing with those two ideas, I would mostly focus this court, I think, on the prejudice inquiry. Again, and I've already gone over it, but I think if you look at the sentencing transcript, if you look at what Judge Gardner said in response to the 35B motion, he simply cannot meet his burden of showing that he was prejudiced by either the procedural bar or by the fact that Mr. Marshall referenced this comment about his alleged impotence at his sentencing.
So if it's successive, are you relying on Rule 35 and then the second 23-110? And if it's abuse of the writ, are you relying on the first 23-110 and the second 23-110? Or is that
Mostly,
right?
yes, although the only thing I would add on the abuse of the writ part is that he also filed a second Rule 35B motion. So I think this is his fourth collateral attack. So, I mean,
Are Rule 35's collateral? I actually don't know the answer to that question, and I'm curious about it, but I'm not sure it necessarily makes a difference here, but
right. Yeah, I think I probably would say it doesn't make a difference. I haven't seen a case that squarely addresses whether it has the label of collateral. But I think the point, the broader point here is that this is his fourth post-conviction motion, and he should not be allowed to constantly keep coming back with issues over and over and over again. And again, I really do think it's
Well-
important. Yeah,
If they are the same issue.
right. And then I was gonna say, and I think it's really important here that he did bring this up to Judge Gardner, the sentencing judge, this issue in his his first Rule 35B motion, and Judge Gardner, again, I think fairly read, said that this didn't impact my sentence.
So the prejudice piece, what exactly does he have to show to establish prejudice here? Is it that the information was false, that the what has to be shown here in order to meet the prejudice prong if we?
He would have to show that the information that Mr. Marshall said worked to his actual and substantial disadvantage.
he would have to show that, or he would have to show a possibility of that.
If the procedural bar is applied, he would have to show the actual and substantial disadvantage. Even if the procedural bar is not applied and we got to the merits, under Hamid, he would have to show a significant possibility. And we have a footnote in our brief, but he can't even show that, I would submit, for the reasons that we have discussed here. And so I think just to sum up here, I mean, what I would say is that what the trial court was faced with, and now what this court is faced with, is a very passing remark at sentencing. There's no evidence that Judge Gardner relied on it at all. In fact, he gave other reasons for giving him this sentence. And then a few years later, he brings up this issue. Judge Gardner essentially says, it doesn't warrant a reduction in sentence. He implies it had no impact on his sentence that would correspond with everything that we see at the sentencing hearing. And he has had several motions over the years to try to resolve this. At this point, he's had a lot of bites of the apple, and the trial court was well within its discretion at not giving him any more bites of the apple, I would say.
Counsel, I wanted to note, and I meant to note this when appellant's counsel was at the podium, that the court did ask our clerk's office to reach out to the United States Attorney's Office for the unredacted copy of the sentencing report that was before Judge Gardner.
Okay.
And I wanted to make sure that both parties were aware of that. And because I think we only in the record on appeal only got 1 or 2 pages of the entire sentencing report. So,
All right. And you, by that, you mean the PSR, Your Honor? You mean the report that CSOSA?
Yes.
Writes?
Mhm.
Okay.
So do you know offhand if the PSR mentioned Mr. Marshall's is that right? Mr. Marshall's statement?
I do not know offhand, Your Honor. So I can, and it sounds like the court still does not have that PSR.
No,
Correct
the
about that?
request was only made yesterday,
I see.
late afternoon.
Well, I'm pretty sure we can get a copy of that. So I will get a copy of that and get it to the court,
Okay.
whichever way makes sense. And then if there are no further questions, we would just ask that the judgment of the Superior Court be affirmed.
All right, thank you.
Your Honor, just starting with the sentencing report, and so that should be in the sealed supplemental record. It was attached, the entire thing, as an exhibit below. Perhaps it did not all get transmitted for some reason.
Right.
but,
Only, I think, two pages we were able to locate, which is why we asked our clerk's office to reach out. So.
Very well. But to answer Your Honor's question, I do not believe that Mr. Marshall's statements were in the, having read it, were in the pre-sentence report. I think he made these at the time of sentencing. I don't think he had made those statements before. The primary purpose, at least from my perspective of including the pre-sentence report, was to show the voluntary sentencing guidelines as one fact suggesting, given trial counsel's representations, that the sentence had far exceeded had been at the top of the guidelines, and it had been consecutive despite a presumption of running them concurrent when they are the same victim in the same incident. But in any event, if not, I'm also happy to provide the entire report to the court.
Thank you. I wanted to mention it in case there was any objection to
Yeah,
having that report from.
None whatsoever. Thank you, Your Honor. A few points in response to the government's argument.
I'm sorry to interrupt you, but we do have it.
Oh, we do have it.
I thought that
We do
would
have
be the
it.
case.
We only found the first couple of pages, so disregard the request. Thank you.
Yes, it should be as an exhibit in the sealed record to Mr. Terrell's motion.
Thank you.
Going back to what the definition of successive is here, I would also, there's been a lot of discussion about that. I would also direct the court again to another case cited in the briefs, Richardson versus United States, which is, the citation is there, but a second 23-110 motion asserting new factual allegations to prove the same legal claim advanced in the first 23-110 motion as this successive motion. And again, we don't have the same legal claim here. I know that the government referenced Sanders, this Supreme Court case from the 60s, and I actually think the example that Sanders gives reinforces Mr. Terrell's position, not the government's. That is, in Sanders, the Supreme Court says, for example, the contention that an involuntary confession was admitted in evidence against him is a distinct ground for federal collateral relief. But a claim of involuntary confession predicated on alleged psychological coercion does not raise a different ground than does one predicated on alleged physical coercion. In other words, identical grounds may often be proved by different factual allegations. So again, here, we don't have the same legal claim at all. That is, Mr. Terrell has never alleged previously a violation of due process.
How do you does that language square with the language of 23-110E?
Yes, Your Honor. So 23-110E says that the court shall not be required to entertain a second or successive motion for similar relief on behalf of the same prisoner. So there are different things. A second motion and a successive motion are different things. And this court has defined what a second motion is and what a successive motion is, each of which modifies for similar relief. So the starting point is, is this a second or successive motion? The other point I wanted to highlight, which is
So you're saying that similar relief doesn't apply to a successive motion? Is that?
So a motion would need to both be successive and request similar relief in order to be for the trial court to have discretion under 23-110E to deny it on those grounds, which I just want to point out here that what the trial court did was not say, I'm not going to exercise my discretion, taking us to the language of 23-110E. The trial court said, because, and there doesn't seem to be an argument about this here, but because the trial court viewed the motion as being procedurally barred under Shepard, that it could not be considered. It didn't say, I'm deciding for these reasons not to consider it. It said, because it fits, and again, I believe erroneously for all the reasons laid out in the briefs, into Shepard, it is denied. And so a failure to recognize discretion is itself an abuse of discretion. So that just because that had not been discussed here, I wanted to make sure that point.
So are you still in disagreement that the 23-110, second 23-110, the fourth successive motion and the third, the motions that seem to seek the similar relief of reduction in sentence?
Sorry, so your Honor's question is whether Mr. Terrell's 2022 motion was successive? Is that the
Yes,
question?
if they're successive, I still am not clear why you would dispute that they seek similar relief. And
So
therefore, they could be considered successive, and the they being the first 35B motion, the second 35B motion, and third, this 23-110 before us now.
So seeking similar relief is not what makes something successive. In other words, in order to be for the trial court to properly exercise discretion to not consider a motion under 23-10E, a motion needs to both be successive and seek similar relief. A motion is successive where it is an identical legal claim to that has been raised previously. That is just not the case here. So we don't even need to consider whether it is seeking similar relief because it is not successive, which is the grounds on which the trial court relied to deny it.
I think that the definition of the successive is the key here.
I agree, Your Honor, and I would just, encourage the court back to Richardson and Bradley, which, and even Sanders itself that the government has cited here, all of which indicate that it is needs to be an identical legal claim in order to be successive, which this is not. For all those reasons, I would ask that.
Sorry, I didn't mean to, before you sat down, I have one quick other question.
Please.
So earlier you said that the trial court's erroneous in your view, and seems to be the government agrees, reliance on Shepherd was not harmless or cannot be harmless because it deprived your client of the opportunity to have the hearing at which he could establish the factual allegations. Would you agree that if, and I know you're not agreeing with the premise of this, but would you agree that if the claim is otherwise procedurally barred on another basis, and I know you said you don't think head applies, tend to agree with that too, possibly. But if it's procedurally barred on another basis, that it would be, that the erroneous reliance on Shepherd would be harmless.
With the caveat, Your Honor, that to the point I just raised in rebuttal here, that is, if the trial court viewed the finding that the motion was procedurally barred on some other ground as dispositive, as requiring the trial court to deny the motion, then the error would not be harmless. That is, the trial court didn't recognize that it nonetheless under 23-10E had discretion, then that would not be harmless. And what we have in the motion here, there's nothing indicating that the trial court recognized that it had the discretion to consider the motion, even if it considered it to be second or successive, which is again what 23-10E says. It doesn't say a trial court shall not, or is prohibited from considering a motion that is second or successive. It says that trial court shall not be required to entertain that. So that is that invest in the trial.
What about
court the
abuse of
discretion.
the writ as a bar? Does that confer discretion on the?
Yes, Your Honor,
Trial
because this
court.
court has analyzed what abuse of the writ means. It has equated with that to being a second motion. And so, yes, it would still confer discretion on the trial court, which the trial court did not appreciate that it had here. So for those reasons, I would say it is not harmless, certainly.
Thank you.
Thank you.
All right, counsel, thank you both for your briefs and arguments today, and the cases taken under advisement. Thank you.
Thank you.
All right. This honorable court is now adjourned.
Thank you as well.